Hi and welcome back to another video on robbery and burglary today. We're going to be talking about the two different offences and we're going to start with robbery. Robbery is defined in section 8 of the Theft Act 1968, very similar to theft, actually comes directly after theft because we know theft is section 1 to 7. And it sets robbery out as requiring several different parts, and the definition is essentially requires a completed theft to have occurred. The defendant must have used force or a threat of force, and that force or threat of force must have been done immediately before or during the theft and in order to steal, and the defendant must have the intention to use force or the threat of force to steal as well. Robbery is an indictable offence, which means it's tried in the Crown Court, and the maximum sentence is discretionary life. We know that robbery can range significantly in terms of gravity of offence, from a simple mugging all the way up to an armed bank robbery, in which case there will be similar, if not the same, offences. Now, if we could work through those different bits, as you can see there, the theft, the force, the threat of force, etc. We're going to work through each of those bullet points now. So the first section is on theft. Robbery requires a completed theft. If there is not a completed theft, there cannot be a robbery. And we can see that in the case of Robinson, where he got in a scuffle with another man, and this man owed money to the defendant's wife. And he thought he had a legal right to take that money. He picked up this £5 that the man dropped and took it. And because he thought he had a legal right, he therefore wasn't dishonest. If you look at theft, you know, section 2.1a, in the case of Holden with the tyres, you're not dishonest if you think you have a legal right to take the money. So therefore, if he was not dishonest, there wasn't a completed theft. And as I just said, if there isn't a completed theft, there can't be a robbery. So in Robinson, he was not guilty of robbery. Coram v. Anderson is a very important case. To most of us, it looks like an attempted robbery or an attempted theft or something along the lines of that. But the court said something really important in this case. They said that as the theft occurred, the theft was actually completed when the bag came loose into the defendant's hands for a very split second. Yes, he did drop it and run away, and that's what makes it look like an attempted robbery or a theft. But because it was in his hands for a split second, the theft had been completed at that point. And therefore, as the theft had been completed, there was a completed theft, and therefore, as he used force to do that, there was a robbery as well. So you mustn't get confused with Coram v. Anderson. If you get something similar to that in a scenario where they drop the bag and run off without it, or whatever it is, it still could be a robbery, as there could be a completed theft there. In terms of force, it's very clearly left up to the jury to determine how much force has to be used for it to be a robbery. In Dawson and James, they jostled the victim as they were pickpocketing him, so very gently bumped into him. And the jury were entitled and did in fact find that that was enough force to be a robbery. In Clouden, the person was tugging a bag away from someone, so they didn't actually touch them directly, but they did apply indirect force by tugging the bag, which therefore applied force indirectly to the person as well. And the court very clearly said that that was sufficient in this case to be force, and therefore that was indeed a robbery. However, in PV-DPP, the defendant snatched a cigarette out of the victim's mouth, and that's the only force that was applied. And the jury in that case determined that that wasn't enough force. So we're not actually totally clear exactly how much force has got to be used. It's clearly somewhere in between Dawson and James and PV-DPP, if not more than Dawson and James. Finally, in terms of a threat of force, so not actually applying physical force itself, just a threat, we can see that in BNR v DPP, which involved a child being bullied essentially by a group of other boys, and they surrounded him and pushed him around, etc. And as part of the trial, he said the victim said he wasn't threatened by the threat of force, which they did make. And the defendants in that case appealed against their convictions on that basis and tried to say that, well, because he wasn't threatened, there wasn't a threat of force, and the court dismissed their appeals and upheld their convictions as they did use force anyway, and they said actually the victim doesn't have to actually feel threatened by the threat of force, there just has to be a threat of force. In terms of this bit of the test, which the force or threat of force has to be used immediately before or during and in order to the theft and in order to steal. The Theft Act is very clear. It says the force or threat has to be used immediately before or during the theft. But a couple of cases came up which have twisted this around really. The first case is Hale. Hale's a really important case for this reason. Two men forced their way into a house. One man put a hand over the victim's face to stop her from screaming, over her mouth, and the other one ran upstairs and took the jewellery box. They then came down and tied her up and left. Now, this case is interesting because the defendants argued that they actually didn't use force until after they completed the theft. So what they said was they completed the theft when they picked up the jewellery box and that was the theft completed. And they tried to argue that they then used force in tying her up. So they were saying, if you look at the definition there, they were saying they used force after the theft, not before or during. Now the court didn't like this, and they said, well, actually, you did use force when you pushed your way in directly into the house, and also you used force when you put your hand over her mouth, so actually it doesn't really matter. But what they did say, and this has kind of caused a contradiction in the law, is they said that under robbery, theft is a continuing act. So when they picked up that jewellery box, the theft didn't stop there. The theft wasn't completed there. It continued to be happening. So the theft was continuing. It was still happening. So when they used force to tie her up, the theft was still happening. So they actually were using force during the theft in that instance. Now that's what's known as a continuing act. But the contradiction here is under theft, under the Theft Act, the same act, theft is not a continuing act, just theft by itself, which we saw from the case of Tapper and Abrahams. But yet theft under robbery, they're saying is, and Hale makes that very clear. And we'll talk about why they did that in a minute and the complications of that under the AO3. Lockley happened a couple of years later and followed suit. In this case involved someone stealing some beer from an off licence or a shop and then assaulting the shopkeeper on the way out. And they again said, as the theft was continuing, it was still happening as he picked it up and it wasn't completed at that point, he did use force during the theft as he punched or kicked the shopkeeper on the way out, so therefore the theft was still happening. What you also must remember, and this is something people commonly miss out, is the theft must be done in order to steal, and you must show that. So that's a really important point that people often miss out. And remember, the mens rea you're looking for as well is intention to use force or a threat to steal. There's no cases per se for that, but you must use evidence from a scenario to support or disprove that. So looking at the implied reasons there and what their behaviour and actions and things like that. In terms of burglary, burglary is covered by Section 9 of the Theft Act, 1968, so just the next section along. And there are actually two types of burglary we're going to look at, Section 9.1a and Section 9.1b. Section 9.1a requires the defendant to have entered a building or part of a building as a trespasser with the intention to steal, do GBH or do unlawful damage. It doesn't matter which one of those, you don't have to do all three, just the intention to do one of those three things. So Section 9.1a is literally, they commit 9.1a the moment they enter the building as a trespasser, if, when they enter that building as a trespasser, they have the intention to do one of those three things. They don't actually have to do anything. Literally, the criminal offence is entering the building as a trespasser with the intention. They don't have to then go on and steal anything. They're guilty of 9.1a at that moment. 9.1b, however, is once they're in the building, having entered the building as a trespasser or part of the building, they then actually do a theft, or a GBH, or attempt either of those. Notice that it misses unlawful damage there. That is only in 9.1a, and we'll come back to that when we look at the AO3 essay. So 9.1b is very much about what you do in the building. 9.1a is what you were thinking as you entered the building, and that's the difference. You can be guilty of both. So a normal burglar that goes in intending to steal and then steals and then leaves would be guilty of 9.1a and 9.1b. Someone that enters a building and then changes their mind and doesn't complete a theft or attempt them or do a GBH or anything like that could be guilty of just 9.1a. And equally, someone that enters for another reason and then does a theft could be guilty of 9.1b, but not 9.1a, because they didn't enter with the intention to do one of those three things. So bear in mind that, but make sure you cover both of them really and discount either one if it's not in the scenario. In terms of these definitions, so we need to look at what does entry mean, what does building, part of building, trespasser, etc. means. We'll have a look at that. Entry, there's no definition in the Theft Act. A case called Collins did give us a definition. They said entry had to be substantial and effective. That was worked away. There was a case called Brown in between these that you don't really need to know, but Ryan's the most recent case really on it in terms of usefulness. And they got rid of that definition. They said it's simply up to the jury. In Ryan, the burglar got stuck in the window as they tried to get in, and the judge quite rightly said, well, it could hardly be classed as a substantial and effective entry because it wasn't substantial because it was only his head and his arm in the building, and it couldn't be effective because he certainly couldn't steal anything because he was stuck in the window. So instead of using that definition, the court simply said, well, let's just leave it up to the jury. So entry is up to the jury to decide whether someone has entered the building or not. In terms of building or part of a building, there's no extensive definition of what building really means, although it does include an extended definition in the Theft Act, which says that it includes houseboats and caravans, and there's a bit more information on that if you want to go into more depth. There are two cases on this which show sort of what a building really is and when it isn't. B&S v. Leathley, that was a sort of storage container, freezer container on wooden sleepers, so big bits of wood. Been there for I think 2 years, connected to electricity, locked door, etc. And someone burgled that, and that was classed as a burglary. However, in Norfolk Constabulary v. Seekings and Gould, It was very similar container, but it was on wheels in this instance. I think it'd only been there a year, but that's not really that relevant. The big relevance is that it was on wheels. They decided that predominantly, as it was on wheels, it was not a building. Although don't get that confused with caravans, as we know they are included under the Theft Act as above. So, two very similar buildings in those. They're sort of porter cabins essentially, but one was and one wasn't a building. Easy way to remember that is B and S, building on sleepers. I can't enough to remember it. And Norfolk, not a building in terms of the N there as well, and the B&S or B&S v lethally. In terms of part of a building, quite often you are allowed in a building. So the college or school you're perhaps in, you're allowed in the building, but they might not be, or part of the university, for instance, but you might not be allowed in certain parts of that building. So for instance, staff rooms, chemical cupboards, IT server rooms, those sort of things. The parts of the building not allowed in. Walkington was to do with a shop. It was a counter, and obviously he went behind the counter, and that was part of a building that he was actually trespassing in. He was allowed in the main shop and not behind the counter. So think about in a shop of a stock room, staff room, behind the counter sort of thing. In terms of trespassing, the main case on this is Collins, which is a bit of a weird case. He actually put a ladder up to a woman's window as he saw her in there, and he went up and she was naked laying on the bed, and he went down, took all his clothes off, went back up the ladder, and he claimed she beckoned him in. They proceeded to have sex, and she later on claimed that she didn't realise it was him. She thought it was her boyfriend. Now, the issue was whether he was trespassing. The law was a bit complicated here because it's quite an old case, and it was when rape was actually included as one of the offences under burglary. It no longer is, so you don't need to know that in any detail whatsoever. And essentially, the point of the case was establishing trespassing, really. It's the same case as we mentioned earlier to do with the definition of entry. It's the same case. And they said the defendant must know they are a trespasser or be reckless as to whether they are a trespasser to be a trespasser. They have to know or should have known, really, that they are trespassing. And in Collins, he claimed that she beckoned him in and therefore he thought he was invited in. So in that case, perhaps he wasn't therefore a trespasser. You can become a trespasser, so you can go beyond permission. So for instance, in Smith & Jones or Jones & Smith, you quite often see it as, he was in his dad's house. He is allowed in his dad's house. That certainly he wasn't trespassing, but when he decided to take the TVs and sell them, he went beyond the permission that was granted to him and became a trespasser. So you can become a trespasser. I always think of it along the lines of, would they let you in if they knew what you were going to do? So if you're at your friend's house and stole something, you go beyond permission because actually they wouldn't have let you in if they knew you were going to steal something, so you actually become a trespasser. So in terms of 91A and 91B, in terms of what you need to prove, so if you're going through 91A first, you need to prove that the defendant has entered, that it's a building or part of a building, that they're a trespasser, so that they knew or reckless, or they should have known that they were trespassing, and that the defendant had the intention to do one of those three things, only one, and then that would mean they're guilty of 91A. 91B, you can need to prove that they're in the building, so if they're having entered, they're already in the building, that it's a building or part of a building, it's trespasser, again the same thing, and that they then have either done a theft or a GBH or attempted one of those. It tends to focus more or less just on the theft, but be aware it could look at an attempt or a GBH as well, although that would be fairly complicated in terms of answering. In terms of AO3 and the sort of evaluative side of this, the first thing really is looking at robbery, the fact that robbery requires a completed theft, and is that really necessary? If we compare it to burglary, burglary doesn't require a completed theft, so if we look at 91A for instance, it's purely the intention, whereas 91B is where you have a completed theft. So why can't robbery be the same? Why do you actually need there to be a completed theft? Why does someone actually have to get away with the theft, for instance, or why does it have to be a full theft to actually be a robbery? Surely in the same situation you would feel threatened in the same way. There is an argument that it is a discretionary life sentence, so actually, it can vary, and if it's not a very serious robbery and there's not, it's not a very serious theft, perhaps they can give a very low sentence, perhaps not even custodial, as discretionary life sentence gives the judge that power and discretion. And equally, if it's a really bad robbery, they could indeed, of course, give a very, much longer sentence. In terms of an armed bank robbery, they could, of course, give a life sentence if they wanted to, as it is within their power to do. But there is some debate there as to whether it is, really, really required there. And it's a fairly weak point to start with, but it's nonetheless one you can make. Perhaps the more detailed point you can go into is on the level of force required. It is very low. For such a serious offence, it is indictable, it's tried in the Crown Court. Particularly if we look at the cases of PV's EPP, for instance, it seems very minor. And of course, the jury did decide that was minor force in that one and therefore not a robbery. But if you look at Dawson and James, where they basically jostled him and then pickpocketed him, is that not more theft? Is it really fair that they're charged with such a serious offence of robbery and the stigma that comes along with that? And of course, as I said, the discretionary life sentence can affect their sentence, and they may have got a lower sentence than perhaps someone else. But there is some inconsistency there. And the other issue there with uncertainty is it makes it difficult for lawyers to predict the law and to be able to advise their clients, because they just don't know what a jury potentially is going to say. They can rely on precedent and rely on previous cases and experience, but it can make it much more difficult. In terms of the third point there is a contradiction with what perhaps the intended law was supposed to be. The Criminal Law Revision Committee doesn't exist anymore. They're very much similar to the Law Commission. They operated in the sort of 70s and 80s, I believe. And they were actually the committee that led to the proposal and the formulation of the Theft Act as we know it today. And very clearly in that report, you can find it, I presume you can find it online, they proposed that the mere snatching of a handbag would not be robbery. However, if we look at the current law, for instance, Cloudham, which is exactly what happened in there, the judges in that case decided that that was or could indeed be a robbery. So the question here is the law contradictory to what was originally intended? Now, what you've got to bear in mind is the Criminal Law Revision Committee is not Parliament, and the Theft Act makes no mention of whether the snatching of a handbag would or wouldn't be robbery. So therefore, they either didn't think about this and therefore hadn't said nothing on it, or they deliberately left it vague for the judges to decide. And it's really one of the two outcomes, neither of which we really know which it is, for instance. In terms of reform proposal, could they make a lower level of robbery, similar to 91A and 91B burglary, where the snatching of handbags, we commonly call that mugging. Could they create an offence of mugging, for instance, which would carry a lower sentence, where there's no force actually applied per se to someone, it's more an indirect sort of force? Perhaps, but again, you've got to bear in mind it is a discretionary life sentence, so the judge can reflect the sentence proportionately to what has happened in that case and the fact that they haven't used force in the same way. It's still a distressing incident. You still had your handbag stolen. Is that perhaps more of a theft? Possibly, but you can see the difficulties there. One of the big issues is around continuing act. And as I said, there's a contradiction in the law because theft under theft is not a continuing act, but theft under robbery is a continuing act. Now, they likely did that because they wanted to convict in Hale and for public policy reasons, and we can see it being played out in cases like Lockley, where it clearly is fair and you would want a conviction in those cases for perhaps robbery and things like that. But there is a clear contradiction there, and it doesn't really make sense that it is different. And you can see the clear contradiction there between Hale and Tackler and Abrahams, the two cases that sort of set those out. They also didn't really need to do it. For instance, in Hale, they clearly said in the case as well that the defendant had used force indirectly from pushing the door open and from putting the hand over the mouth. So they certainly didn't need to come up with this continuing act issue, but they did, and that's where we're left with, and it's certainly an interesting area to debate. Moving on to burglary now. There are anomalies between 91A and 91B, so between the two offences. One of the major ones being that unlawful damage is mentioned as one of the trigger offences in 91A, so one of the offences you have to intend as you enter, but it's not mentioned in 91B at all. So 91B clearly has just theft and GBH and attempted either of those. It makes no mention of unlawful damage whatsoever. So what that means is, if you enter for another intention to do something, an honest intention perhaps, and then do unlawful damage in the building, you wouldn't be guilty of 91A or 91B because it's not mentioned there in 91B, and you didn't enter with the intention to do it in 91A. So you wouldn't be guilty. You would, of course, be guilty of criminal damage and stuff, but you wouldn't be guilty of 91B. However, if you entered under 91A with the intention to do it, but then never did it, you would be guilty. So clearly that makes no sense. Like, actually entering with the intention to do it, you'd be guilty, but actually doing it, you wouldn't, which doesn't seem to make any sense. Whether that was just a mistake and whether it should be added is questionable, and that could be a reform suggestion in terms of adding it. It's also worth bearing in mind the removal of rape, which I think was in 2006, or at least in the 2000s. from being one of the trigger offences, and I think that's a really good societal move. I think it was probably in there, and I may be corrected from a sort of a sociologist or a study of a lawyer, but I think it may have been in there harking back to offences to do with rape being around women being property and things like that, which is obviously a horrendous concept that we look back on with absolute shame and absolutely shouldn't be part, obviously quite well is no longer part of the law. And I think it possibly ties back to that. I couldn't say that with any certainty, but I think that's a useful concept to say, well, actually, it's good that they've reformed the law and taken that out and put that in Sexual Offences Act, where it rightly belongs, under sexual offences. Burglary, most people associate with being a theft, certainly not a rape. So I think that sort of fits better with people's interpretations of what the law really is as well. Obviously, with 9(1)A particularly, proving that someone had the intention when they entered the building, that can be really difficult. It's difficult to prove mens rea, it's difficult to prove what someone was thinking. The only way you can do it is prove by or try and imply by what they had on them or their behaviour. So if they have spray cans on them, you may imply that they were going to do unlawful damage. If they had a crowbar or something like that, similar, or maybe theft or something along those lines, or a knife maybe for the GBH part, or a gun, etc. But it can be really difficult. And that makes it very difficult to prove, to prove 9(1)A. One of the reasons they probably introduced 9(1)A, as well as just normal 9(1)B burglary, is largely because the clean-up rates, the actual convictions for burglary, are very, very low. They're around 6 to 7% annually, really, although that does chop and change. And that's largely because it's just really hard to catch burglars in the act. And then, of course, if you catch a burglar with the stolen items, they quite often will say, well, I got them off X, Y, Z, or from someone else. And the most you can probably charge them with in that instance is handling stolen goods rather than the actual burglary themselves, unless you can match DNA evidence or CCTV of them at the burglary, which is usually fairly, fairly rare. And that does go to some extent, in explaining why we have 9(1)A, and to try and maximise that chance that you can catch a burglar and convict them of it. There are sort of definite lack of definitions around sort of entry, trespasser, or parts of a building and things like that. That in most of them, they've left them up to the jury, and that, of course, can cause inconsistency, which we'll look at in a minute. But these lack of definitions, it just creates complications and uncertainty. But of course, the bonus you get from it is flexibility, and the fact that the judges or the jury can make decisions based on case-by-case basis and what really feels fair and appropriate in different cases, really. There is inconsistency around the decisions in entry. We saw how it moved from being a definition of substantial and effective down to just being left to the jury. And of course, where you get different decisions, that again, as I said, creates uncertainty, and it's difficult for lawyers to predict, and the same sort of arguments as we talked about before. Similar with buildings, most buildings would be clearly classified. You've got issues around things like tents, circus tents, and porter cabins, as we saw with the cases of B&S v Leithley and Norfolk Constabulary v Seekins and Gould, around the sort of porter cabins. And it just seemed particularly unfair in both those instances. In both those cases, they were using them as buildings, essentially, for storage. So it's a bit silly that one was a building and one wasn't, just because one was on wheels. But I guess they've had to draw a line somewhere and distinguish the difference between vehicles and buildings. So it's worth bearing in mind in that one. And would we benefit from an extended definition or a greater definition of a building? Maybe, in terms of a reform suggestion. And issues around trespassing, going beyond permission. Going beyond permission, is it not really just theft? If you invite your friend round to your house and then they steal from you, is that really, have they become a trespasser because they've gone beyond permission? Well, not really. They are essentially just stealing from you. They have got permission to be in the house. They're not trespassing, really. But yet the law very clearly says they are going beyond permission, so they become a trespasser. So in fact, it could be certainly 9(1)B burglary at least, because presumably they didn't enter as a trespasser because they originally had permission. So it's worth bearing that in mind. In terms of a scenario, quite often it's likely that you could get a scenario that includes one robbery and one burglary, although that's not for certain. And possibly it could be a 9(1)A and a 9(1)B, or just one of them, although it would always be wise to explain why the other one wasn't met. Obviously, with robbery, you're looking for some sort of use of force to distinguish that one. I certainly wouldn't explain theft in detail. It might be sensible to refer to the wording. So, for instance, dishonesty, appropriating property belonging to another with intention of permit to bribe, etc. But you certainly wouldn't go through in depth, unless the question demanded it, which it most likely wouldn't. and the same situation may be a robbery and a burglary, so just be aware of that as well. So for instance, Michael enters the store intending to steal the cash in the cash register. Obviously, as he enters the building with the intention to steal, as a trespasser, blah blah blah, he's guilty of 91A. When he points a gun at the store owner demanding he puts the cash in Michael's bag, which shopkeeper does, he's arguably committing a robbery. And then when he leaves with the money, he's committing a 91B because he's completing a theft after he's entered the building as a trespasser. So bear in mind that the same situation could in fact be all three, or some sort of combination of them as well. Hope you found that really useful, and stay tuned. There should be some more videos going up later this week and early next week on topics such as murder, involuntary manslaughter and other topics like that. Thank you very much.